Mr. Magee just entered a plea of guilty to 1 count of voluntary manslaughter, and our negotiated sentence was 20 years, served 17. Well, Mr. Magee went through a full trial in 2008, so he saw the evidence that was presented, he heard the testimony of the witnesses, and he knew even then his conviction was very circumstantial. There was not a single eyewitness, there wasn't a fingerprint, they didn't have DNA. It was very circumstantial, and it was enough to convict him, and he was sentenced to life. So to take that chance again, he was aware of the dangers of that. So being presented with this offer that could potentially give him a date certain to go home, even if he maxes out at the 17 years, he still has a date that he can go home. So it was very appealing to him.
Like any case, I have to evaluate the strength of my evidence when I'm making a determination about what to do on a plea. And in this case, I had real concerns about whether we could get a conviction or even a verdict on the case. This was going to be a case that was problematic in terms of retrying. I mean, again, we're dealing with events that occurred 14 years ago, which can always be an issue in terms of the recollection of witnesses and so forth. In addition, more than one of the witnesses in the case, including the main witness for the state, were deceased, and so that was an issue. This case was back for a retrial because of problems with the transcript in the original trial. The court reporter essentially had done such a poor job on creating a trial transcript that its reliability was called into so much question that the judge actually ordered a new trial.